Next up, legal D&I, how to secure the legal interest of a company and its employees in the area of D&I. Joining us today, Beata Baran, PhD attorney at law, partner at Baran, Książek, Bigaj law firm. Good morning.
Good morning. Thank you for the invitation.
Beata, it's great to have you with us, and I personally find this topic especially interesting today because many people believe that D&I is pretty much a company leadership and perhaps HR initiative with bits and pieces of bottom-up initiatives coming from middle management and employees themselves. So can we start with the most fundamental question, perhaps? Why should we even think of making lawyers part of the conversation?
Well, many important points have already been raised during the discussions yesterday and today. And among them, there was a voice from Franklin Templeton representative who underlined how consistency is important. And I agree, but we are lawyers. When global internal policy of the company became a part of internal local law of an employer, the wording of the policy is the crucial point. The wording creates legal issues, legal effects. And here, when implementing or creating, working on D&I regulations, there is a space for cooperation between HR department, HR team, and the legal team. Wording of the policy, wording which is used, is in fact the clue of the issue. The same word can have different meaning in common language and on legal basis. Also, the right translation makes difference. For example, expressions like should versus have to, or may versus must. This part of work, implementation or creation of the D&I policy, is the first area for cooperation between HR and lawyers. Having in mind that diversity and inclusion is the issue or the matter which cut through complexity in an organization, that means that also legal aspects is involved. And there are, in fact, several points of D&I from the legal perspective. Firstly, this very first step, or implementing the global regulations to the local entity, then the stage of preparation, drafting the D&I policy, especially in this implementation in international companies where we have this issue of translation, because the mother tongue of the headquarter is like English, German, French, or any other language. Then there we have the kind of next second step, which is compliance between internal policies with the general legal regulations of the given country, of our, let's say, national legal regulations, the general legal regulations. So there is still the space for lawyers to be involved in the whole process. And I think I can distinguish some more points when lawyers can help, can support the organization, the employer. The other points are execution of internal regulations. And here we can distinguish two more aspects, training and internal investigations, especially in case of breach of internal regulations. So what can be really helpful in conducting like internal procedure, what has happened, what is the outcome, was the law or the internal regulations broken or not. And finally, supporting the company during the potential court proceedings. So generally, the D&I is a perfect space for cooperation between two departments, and lawyers being friends of HRs here.
Beata, let me stop you right there for a while, because what you're saying, for now at least, we are focusing on the linguistic sensitivity aspect to different D&I documents and policy statement risks involved in that. At the same time, we are trying to push this discussion in a direction that makes it more inclusive, more relatable for employees. So the moment an employer engages in conversation with lawyers, drafting every single word, from employee perspective, there is a risk it will be seen as sterile, cold-hearted, very technical, very lawyer-like language, in the sense that, well, if you look at just plainly stereotype level, there is a perception, whether it's true or not is for you to comment on, that lawyers tend to complicate things rather than simplify things. So let me ask you this. How can a professional legal office help D&I practitioners from the very start?
Yeah, that's a very good question. Let me comment it on some kind of multi-dimensional support and the role of lawyers with the D&I process implementing, starting in the company, and the steps or the areas where lawyers can help HR managers or D&I specialist managers. First of all, there is a role of a lawyer as a consultant regarding the internal policy implementation. Then there is another point, the role of a lawyer as an expert regarding the compliance of the internal policies with the general legal provisions. And then we have kind of third step, which can be described as a supporter, a lawyer as a supporter in verification of irregularities, which can occur during the execution of internal policies, also D&I policy. Then there is another role of lawyer to support as a trainer, as a person who will be able to explain, to make the regulations understandable, both for employees as also for the employer, the managers who are responsible for introducing it. And then also, last but not least, lawyer as an HR team friend. Lawyer is the one who can help in finding the solution to an emerging problem. Let me elaborate a little bit more to make it more clarified. So lawyer as a consultant regarding the internal policy implementation, we can help not only in structure of the D&I matters, but also, as you mentioned, in the wording of the policy, of the internal procedure, which can be more clear or more understandable to addressee of these documents. Our legal knowledge can be also useful in checking whether the D&I aspect is not contrary with other internal documents. For example, anti-harassment policy, or whether it doesn't double other regulations, for example, code of conduct. We can also provide an organization with legal tools to execute the internal policy, to make it a live instrument internally. For example, helping with establishing a whistleblowing system, which can lead to bring to daylight any irregularities and or breaching of the D&I policy, as well as other documents like anti-harassment policy or anti-discrimination policy or code of conduct in any other aspects in an organization. Lawyer is also yeah.
Allow me to ask you a more tricky question then, because
Sure.
I'm quite sure that a great many percentage of people watching us today have already come across issues that you're talking about and have had to consult lawyers in trying to solve them, work on compliance, etc., etc. But let's focus on a slightly more difficult scenario. Imagine a company becomes a little frustrated with what is going on around them in terms of discrimination across the different areas where discrimination occurs in societies. And as a result of becoming a little more emotional, you will see employees raising more and more bottom-up initiatives like, let's support this, how can this be done, etc., etc. And eventually, what may happen is that the company takes the whole thing a step further, asking its employees to be a little more declarative about their values and D&I position, which really starts the risky territory. Can you comment on that, the language of declarations whenever it occurs?
Yeah, let me focus on this issue. There is a common practice that employees got acquainted with internal policies and regulations, also D&I policy if it is implemented in the company. And here, what is important it's that the employee understand the D&I policy. Not the signature of the employee is the clue here for the policy to be binding, but the wording of the document, of the internal regulations. And the issue whether an employee is obliged to follow the policy may be examined by a court. The court, of course, can check whether the internal policy is compliant with the general legal provisions or not. And here we are back with the issue I tackled at the very beginning of today's meeting. I mean, the wording of the policy is the clue. And here is every case regarding such a situation should be assessed individually and separately.
Beata, after talking to you, I'm afraid every single D&I officer will be afraid to raise their pen from the table before even starting to draft something. So you're hardly encouraging for them. So let me ask you this. At what stage should a company consult a legal practice? When starting the whole conversation, or obviously not when it's already close to a court case?
Yeah, that's a very good question. As I mentioned before, the legal support is the most beneficial for the organization, for the employer, when it starts parallel to the first step of D&I implementation. Creating and drafting, preparing, implementing the D&I policies is the moment when a lawyer can point a red flag with any incompliant or risky provisions included in the internal regulations or translation of the internal regulations. Then the legal support can be provided also on the next steps during the execution of the policy. For example, during the trainings or conducting internal investigations, which are also a legal tool to see what's going on in the organization and how the policy works. The court stage is the last one. We as lawyers who are involved earlier in the process regarding the D&I, we do our best not to send the case to the court. And there are also some legal tools to close the case on pre-trial stage, for example, mediation. And it's also worth having in mind that court proceedings in Poland is extended in time, is also quite expensive, and last but not least, also can be stressful.
Fair enough. Over the years, it seems fair to say you have probably specialized as a law firm in handling discrimination cases. Would you say one can talk about a trend on the market? And if so, what kind of trend?
There are several aspects which can be rise up here. Firstly, before going to the court, what is important is to take steps which can make prevention or mitigations the chance that the case will go before the judge. And these two aspects which should be rise up here are the understanding of the legal norms, both internally legal documents like policies, procedures, and also the general legal regulations. And the other aspect, the second leg, let's say, is the right communication. The right communication internal also in the organization. And before going to the court, there is still this space for the cooperation between HR team and the legal team, which is in fact crucial. And this kind of synergy can help to solve the conflict on internal level, the problem on internal
Are we
level.
talking about
Yeah.
are we talking about cooperation in the pre-court case stage, during the court case stage, when?
We can say about, in fact, both, but firstly on the pre-court, pre-trial stage, there is always there is a space for education and promotion of company values, and its understanding, the understanding of what's already implemented before the case escalates so far that the only way to solve it is on the court in the courtroom.
But
Uh,
we're
yeah.
we're talking about inclusion, Beata, quite a lot. It's a very important term in this entire debate. So let's try and build a little bit more empathy into this equation and imagine a situation. We're talking about how legal firms can cooperate with D&I and HR, but imagine a situation where you have a single lawyer, a single person, a single employee who feels discriminated against in a company. And then what we are talking about is that D&I and HR and law firms, preferably big, experienced and expensive, should join forces to fight the battle, right? But let's try and imagine slightly a little bit more from the employee's perspective. How can this equation between D&I, HR office, and a law firm establish ways and means to avoid the conflict, or actually to prevent the conflict from escalating, instead of joining forces and establishing a stronger force against usually a single person?
Yeah, that's the right point to evaluate a little bit more on it. So when dealing with such situation, let's call it core case, dealing with discrimination, dealing with harassment, which also can occur, uh, we see clearly that the understanding of organizational culture, its promotion, education, and also the contact, the communication to the employees, together with right showing of showing the internal values, the internal regulations, can be the key for a better workspace, and in a result also less court cases or less escalated cases. So what I will say that I will not say that there is a contrary between employees and HR or the rest of team who is supporting them. There should be this open for dialogue, for this communication and mutual understanding. This place for as I said a little bit earlier, these trainings, this giving space to understand what we want to share as a company, as a team, in fact. So,
Beata,
also, yeah.
Beata, during the last session, we had two very interesting questions coming to us through the chat, but they reached me a little too late and we didn't have enough time to ask them. Hopefully, our panel members will be able to answer them via the chat. But I have two more questions for you. One out of curiosity, which I'm sure our audiences will be sharing. If you think about the total number of discrimination court cases you've been handling over the past 1 year, is the total number on the rise or on the decline since employees started working from home?
It's not easy to answer on this question,
You
because
see,
there's
I told you.
yeah, exactly. I totally agree with you. The home office started, in fact, several months ago, and also the court proceedings were not fully working on a daily basis because of the COVID time, of course. So we can assess, we can evaluate it after several months. Where it will be possible to assume the numbers and compare them to the numbers from previous years, how they changed and were even we are on the rise or not. But nevertheless, the situation, as it's so unusual, that we have to be ready for any scenario. The risk is high,
Beata,
I suppose.
Beata, we have 5 seconds left. So, one word of advice, in addition to being extremely careful about the actual wording and the linguistic part of whatever you come up with as a company, what would be your golden advice to close with to companies when it comes to D&I policy?
So the golden advice is firstly to consider how and what you want to share in the terms of the linguistic aspects of the wording of the internal regulations. And I suppose this one is a good starting point for the next steps to legal in the legal terms, the next steps of the including and implementing D&I.
Beata Baran, PhD attorney at law, partner at Baran Książek Bigaj. Thank you very much, Beata.
Thank you very much.